Hi everyone. There's a couple of you coming in. Can you hear me? Is there a way for you to let me know? I'm hoping the chat works. Yes, the chat is working. If you can hear me and see me, let me know. I'm going to share my screen now. Got a couple of minutes before. There we go. Midday, my time, 12:30. Many of your times. We'll get started. I haven't heard from anyone if you can hear me yet, so I'm going to wait while I do this tech check. Anna, can you hear me? Is that what raising your hands means? I hope so. Very good. Excellent. Hope you're all doing well on this beautiful day. All right, well, we've only got half an hour together, so I'm going to get started while people filter in. I've got the Q&A up on one of my screens, chat, so if you have any questions throughout the day, let me know. I've got hands coming up. Joe and Leanne, I hope that means you can hear me. If the chat isn't working for you, maybe pop it in the Q&A. I am just going to proceed on the basis that you can all hear me until someone tells me that I'm just talking to cyberspace. On that note, I'll get started. Thanks everyone for coming. We've had a lot of registrations, so very happy that this is a subject that is really resonating with people because there's been some recent changes, so I thought it was important to have this discussion with you all. Today we're going to be talking about staffing strategies for medical practices and clinics and understanding when to hire employees versus contractors. And that might seem like a simple sort of premise for this webinar, but the more that you dig into it, the more you find that it isn't as simple as you hoped, I think. All right. Q&A. Okay. See and hear you, but chat disabled. Okay, perfect. Thank you, David. Thank you, Joe. So yes, any chat needs to happen in the Q&A button this time. Sorry about that. Always some tech challenges, aren't there? All right. So you would be disappointed if I didn't start today's session with a disclaimer. I'm going to be providing general information only today, and really do recommend that if you've got any specific issues to get your own personalised legal advice in relation to the situation that you're in. Who am I? Hopefully, you know, we've come across each other already. Many of the names on the list today I did recognise, so welcome back. My name's Sarah Bartholomeusz. I run a commercial law firm. It's called uLegal. We work with medical practitioners and allied health professionals, so people who work in the health industry, and we're very happy in that niche. I come from a family of medical practitioners, mostly surgeons, some dentists, some allied health people, physios, nurses, all the different health professions. And so it's a cohort that I care deeply about. And also it means that I come to work every day knowing that I'm helping people who help people. And that's very meaningful for me. And I feel like it's also very meaningful for the whole of Australia. So that's why I do what I do. I've written a book called Growing a Medical Practice from Frustration to a High Performance Business. It's a great guidebook if you are starting a practice or running a practice and wanting to know how to make sure that you're legally up to scratch with things. Of course, it's always changing, the legal landscape, which is why I'm here today. but it's a good opportunity for you to kind of get some runs on the board if you have a look at that book. It's available on our website to purchase, so have a look there. Or I actually read it in an audiobook as well. So if you've got Audible and you've got credits on there, then feel free to use one on that book. All right, let's get into today's session. What the overview will be is looking at the different legal options for engaging assistance, the complexities that specifically exist within health, and then the importance of understanding the legal implications of whichever way you decide to go. So understandably, when you're looking to bring someone new into a practice, a lot of focus is on what's going to reap the most benefit and minimize the most risk for you. And one important element for you to consider is whether or not you engage an independent contractor or hire an employee. This decision can be a bit more complex within health and medical because, as you probably know, many practitioners, whether they're in allied health or medical, wish to work as independent contractors or independent practitioners within a practice. So for practice owners, there's quite a lot to consider when answering the question, should we hire independent practitioners or should we hire employees? Because it's not always your choice. You might have some flexibility if you're in a medical practice and you're wanting to rent a room to an allied health professional and have that really arm's length relationship, then it might seem a lot more simple. And also then, of course, there's the financial implications of whether or not to hire an independent contractor or an employee. And it's important to do those numbers to work out what's going to work best for your business. Understanding the options. So there are multiple ways that health professionals can be engaged, and no doubt you might have even heard of all of these models, but I wanted to go through them anyway. Health professionals do often like to be more independent because it is perceived by them as being a more flexible choice. They think they can take as much leave as they like, which as truly independent practitioners, they can. They also think they're going to be paid more as independent contractors, which may or may not be true depending on the type of professional they are and depending on how you structure the arrangement. But because employees and contractors are really the most common ways that you might wish to engage practitioners, in this session, I'm going to do a deep dive on each of these. There are a couple of different ones. So, service arrangements with independent practitioners could be a way that people are engaged, or just a simple room rental agreement or license agreement is the legal term. So those options exist as well. They're slightly different legally, but because there's been some recent changes to the Fair Work Act, I thought it would be useful for you to understand really the difference between employees and independent contractors and where that line can be crossed unintentionally by practices and risk can be created. So look, what I want to do, which is what I always want to do, is minimize people's risk in their practice, because this is something that you as a practice owner or someone working senior in a practice really don't want to get wrong. And I'll explain why as we go. In the eyes of the law, a contracted practitioner might, in some circumstances, be deemed as an employee. As if it needed to be any more complex, there is such a thing as being an employee for all purposes, but also for superannuation purposes or for payroll tax purposes. And this can become highly problematic for you as a practice owner or a practice manager, but it will be highly fact dependent and will be determined based on a multitude of indicators and a multitude of tests. So when I say it's a complex landscape, it really is a really very complex landscape that's different in every state and territory, just to, make you sleep better at night. I had somebody come to us this week actually who had an employee who had become an independent contractor after they had resigned, but they were still going to see a certain number of patients, and they had entered into an independent contractor, which actually, unfortunately for our client, had all the hallmarks of being an employment agreement, including the requirement to wear a uniform, the requirement to be restrained in their future dealings. So I'll go through all of the different issues that might come up in contractor agreements that might deem someone an employee, because it's important for you to understand. So it has been a complex landscape for many years, and it's really left many practice owners and practice managers to grapple with the potential issues around superannuation, leave obligations, and also to consider the risks of sham contracting. There's also been a case recently called Thomas and Nas and the Chief Commissioner of State Revenue, which is a New South Wales case that has brought to light additional tax considerations, prompting many practices to evaluate risks associated with retrospective payroll tax bills and future obligations. And this is something I'm going to do a whole separate webinar on next month. So look out for the invitation to that one as well, because it's an ever-evolving and changing space, payroll tax in Australia, different in every state and territory, which makes it really easy to do a webinar on. But I know that it's something that many practice owners are across already. So typically, when a practitioner is hired as an independent contractor, they are in effect running their own business with an ABN and all of the obligations that go along with business ownership. That is, they'll be responsible for their own tax and their own superannuation generally as well. If they're deemed to be an employee, the practice is responsible for paying the practitioner's superannuation, payroll tax, and also any leave entitlements. So that can include maybe some obligations that you might not have considered when you were first entering into an arrangement as an independent contractor. The main risk for practices or clinics is that it is not actually you as the owner or the practitioner you're bringing on board that makes the decision as to the terms of the engagement. Even if you have a contractor agreement in place, it is the law that decides if someone is a contractor or an employee. Unfortunately, I've seen cases where, for example, a contracting practitioner chooses to leave a clinic and it has transpired that they should have been classified as an employee. As a result, upon exiting, the clinic owners were left with a hefty tax bill for unpaid payroll tax, superannuation, and leave entitlements to cover as well. For this reason alone, it's a worthwhile exercise to make sure you know what's involved in determining whether your contracted practitioners would be classified as employees and ensure everything is set up correctly from the start in accordance with the law. The example I gave earlier about the practice owner who'd entered into an arrangement with a contractor, but it was actually an employee, was extremely frustrated at the cost that's being incurred in kind of unwinding that arrangement. And I always say it is a lot cheaper to get the advice up front than to be trying to deal with a dispute situation. So just want to hammer that home. We prefer to kind of get to you before there's a dispute and make sure that the arrangements you're entering into are correct from the outset. So what's also important now, though, is that it's also important that the contract terms that we prepare for you actually reflect what happens in your practice or clinic. can't put something in writing and then do something else, or there can be risks created. So this is a recent act. There's been some amendments to the Fair Work Act 2009 for constitutionally covered businesses, which essentially means if you're a company, if you're not operating as a sole trader, then this determination in relation to the whole of the relationship is now being made by considering not just what the contract says, but also what happens in the clinic, or what the law says is the whole of the relationship, as reflected in the terms of the contract, and additionally, how the contract is then performed in practice. This new test differs from the previous test, which placed a focus on the terms agreed in the contract. In practical terms, this means that going forward, even if the agreement terms clearly indicate the relationship is one of principal and independent contractor, they could still be considered an employee based on how the contract is performed in practice. Therefore, if contractors challenge their engagement status, they could be successful in seeking employment-related benefits, such as unpaid leave entitlements or superannuation. Determining whether a worker is a contractor or an employee in practice and in the contract depends on a number of indicators, which I'm going to get stuck into now. The most important part of making sure that you're on the right side of the law is understanding the indicators that help determine whether a contractor or an employee relationship exists. We can't call them rules, unfortunately, just not that specifically, because each indicator alone will not determine whether a relationship is that of a contractor or an employee. Bear with me too, as there's quite a lot of different factors for us to turn our minds to, but we'll get started with one very important factor, which is the level of control or independence that the practitioner has. So independent contractors have control over how many hours they work and what hours they work. If you dictate that your contractor will be working a certain place, a certain time, and when and how they perform their work, you may in fact be positioning yourself as an employer. We understand that this creates huge difficulties for clinic managers who really need to ensure that there's practitioners available consistently within the practice to see clients. However, let's say, for example, you engage a practitioner to work Monday, Tuesday, and Wednesday. That's not necessarily taking away from their control and independence, particularly if we consider that these hours were likely negotiated with the practitioner during the hiring and contracting stage. If, however, you've engaged the practitioner on these terms and you then make additional demands or requirements, such as they must arrive 15 minutes before their shift for a team meeting, or they must be available or on call after hours, then this is moving into more of an employer-employee relationship. Other examples of this include expectations that they schedule at least a certain number of patients or clients a day. They must not take more than, say, 2 15-minute breaks in between scheduled appointments. You can start to see how this quickly starts to include more control than a true independent contractor relationship. The next indicator is exclusivity. A true contracting practitioner will either work for others or be permitted to do so in both practice and the terms of the contract. For example, if the contract says that it was a non-exclusive relationship, but in reality they need to work 38 hours a week, it's hard to say that they could it's hard to say that they're free to work for others. Another factor is how the practitioner is paid. Traditionally, it's expected that a contractor will set their own fees and be paid for results as set out in the contract. Contractors are also responsible for their own tax obligations and do not receive sick leave or other leave payments. There are many ways in which the payments can be structured that we've seen in our experience. For example, from patients paying the practitioner directly to practice managers paying per hour or per day, patient seen, the rebate less the rental of the consulting rooms, or a rebate less a service fee. Each of these structures presents varying levels of risk. However, a payment that is calculated on time given by the practitioner is more likely than not to be an indicator of an employment arrangement. On the other end of the spectrum, an arrangement in which the full Medicare rebate is remitted to the practitioner and the practitioner pays the practice a separate service fee is more likely to indicate the presence of a contracting arrangement. Now, one of the hallmarks of a contracting relationship is an unrestricted right to delegate, again, in both the contract and in practice. The true contractor should have this, whereas an employee is engaged personally to do the role. Therefore, they do not have an inherent right to delegate. This is another challenging indicator for practice managers and owners, and it's not difficult to see why. You invest time in ensuring that you're engaging the right practitioner for your practice, someone with the right experience and skills, and you don't particularly want that person to delegate their role under the contract to one of their employees or a different independent contractor, particularly where you cannot determine whether that practitioner possesses the experience or skills that you might expect or your patients might be expecting. Another question to ask is who bears the risk? It's said that the risk runs with the control of the contract, meaning when you transfer independence and control to a practitioner, you're also transferring the risk. As self-employed practitioners must hold their own professional indemnity insurance. However, caution should still be exercised. Where a contractor's agreement assigns risk to the practice for work performed as a contractor, it may indicate an employer-employee relationship. If your contractor is a practitioner, your contract should contain a warranty that the independent practitioner will always hold sufficient and valid professional indemnity insurance. In fact, somebody that I was talking to yesterday, I suggested that they receive a copy of the certificate of currency of that insurance once a year. And that's something to put on your list of to-dos each time your insurance or professional indemnity insurance renews, to ask all the independent practitioners for that. Because I have seen a case where somebody wasn't asking for it and the person was not taking out insurance and they just were kind of winging it, but they never got asked for it as well. So you need to kind of make sure that you're enforcing the clauses of your contract, including protecting yourself by understanding that people are properly insuring themselves. And you might think, well, it goes without saying that they will, but sometimes people are experiencing things in their life that mean that they might not be as diligent as time goes on as you might have experienced them as at the beginning of the relationship. So having a reminder in your calendar each year to do that is probably a sensible idea. All right, we're almost there. True contractors also provide their own equipment. In some circumstances, such as where that equipment is expensive or specialized, for example, ophthalmologists is a good one, or dentists, it might be necessary to share resources so that your contractors use this to undertake the work required. As a general rule, however, it's important that contractors are responsible for providing their own tools, including laptops and other equipment required for them to complete tasks for patients. To wrap these last three up here quite quickly, because we have touched on them briefly earlier, true contractors are not entitled to leave as they're running their own business, so paid leave. They're not part of yours. In contrast, an employee will be engaged personally and will be tied up in your practice's business. I cannot stress enough that each factor alone is not determinative. For example, even if you structure the payments correctly, if the practitioner has no control over their work, uses only the facilities of the practice and is not able to delegate, it will still suggest the presence of an employment relationship. These factors are important to consider when you're assessing those you have already engaged, but also looking for future planning. For example, if you know that you would like to have control or foster a particular practice culture, it might be time to consider employment relationships, and we're seeing many practices do that more and more. Alongside the common law, the main piece of legislation that relates to whether practitioners will be employees or contractors is the Fair Work Act, as this governs all Australian workplaces. It's the foundation for all standards and regulations for employment, so every employer should be familiar with it. I've even seen recently that the Fair Work Act is also being used in relation to offshore employees. So if you do need any particular advice about that, really treating those internationally based employees as though they're part of your Australian team is the most sensible step to take to avoid risks in that regard. There are also other pieces of legislation and obligations for you to consider. Nestled under the Fair Work Act are the relevant awards. The awards set out the specific minimum wages and working conditions per profession. There's an award that covers most allied health professionals, which is the Health Professionals and Support Services Award, which I trust you already know about, or if not, you'll become well acquainted with in the near future. These awards detail entitlements such as how many breaks an employee should be provided with, what overtime hours are, details about allowances for travel, training, or uniforms, etc. Also, as an employer, you need to be familiar with any ATO obligations such as income tax and pay-as-you-go withholding tax. This is where practices can run into difficulties. This is because the ATO has been given very broad powers to audit and recover tax, and they have authority to make determination about whether your contractors are, in fact, employees for tax purposes. Calling someone a contractor means very little to the ATO because if the ATO views the relationship of a doctor or allied health professional to your practice as an employee relationship, they will very likely enact their powers to recover that tax. The other piece of relevant legislation, which is included, is the Superannuation Guarantee Administration Act 1992, and this governs your practice's obligation to pay superannuation. It's important for you to know that engaging a contractor does not automatically relieve you of the obligation to pay superannuation. Under the Superannuation Guarantee Scheme, if you pay a contractor mainly for their labour, you may be required to pay superannuation. And we've seen some agreements that bundle superannuation into a payment to an independent contractor, and that may not be allowed anymore. You should look into that or review your contracts because it might be that superannuation needs to be separately paid into a super account because of these recent changes. There's also recent rulings by most state revenue officers to consider in relation to payroll tax and workers' compensation obligations to consider as well, which vary from state to state. Sometimes contractor relationships are used by employers to avoid their obligations. If the Fair Work Ombudsman finds that you're intentionally avoiding your obligations by directing employees to undertake work as contractors, and we've seen that in some bigger health businesses where employees have been moved into being contractors, but essentially there's been no change in the arrangement. You should be aware that you can be fined up to $93,000 per contract, and that's for smaller businesses with fewer than 15 employees, and $469,500 for businesses with more than 15 employees, which is significant. And in the case I'm thinking of, there were a number of professionals who they were moving around, and that fine would have been extraordinarily big if they were in fact fined for that conduct. The case I mentioned earlier was just one example where a practice has unintentionally got it wrong and subsequently faced a hefty bill of superannuation that they didn't expect to pay. It highlights the importance of making sure you correctly classify practitioners and understand the obligations that then attach, so that you don't accidentally not pay the requisite entitlements, whether that be for payroll tax, superannuation, or other entitlements like leave or paying workers' compensation is another one. It isn't all doom and gloom though. There are steps you can take to minimise risk in your practice. It's wise to leverage the expertise of someone with significant experience in this space to help you ensure that you're acting within the parameters of the law. We suggest engaging a specialist in health law to assist you. As specialist lawyers for health professionals, we can help you to get the structure of your contracts right or review what you already have in place. This alone is not enough though, and it must be considered alongside the practical aspects of the engagement. Just before I finish up, I'd like to share an example of a client who approached us recently. They weren't certain about the best method of how to engage a practitioner and consequently the appropriate contracts to use. We took the time to understand their objectives, how they envisioned this practitioner's role within their practice, and the level of control that they wish to maintain. After a thorough exploration of all the different engagement models, clarified the implications of each option for their particular practice, such as the limits that they might face fostering a culture or requiring adherence to practice policies. For example, if they were trying to exercise certain control over a contractor, it could put them at risk of positioning themselves as an employer. However, certain parts of their intended relationships reflected a true contracting relationship. Based on this, we provided a detailed letter of advice which empowered them to make an informed decision. We're now assisting them with drafting an employment agreement to align with their chosen approach. Now, that case study shows how it's important to think about the distinction before you engage the practitioner, but also, of course, as we've highlighted, correct classification as an ongoing consideration and obligation for current practitioners working in your practice, because we have seen the law changes and as lawyers, unfortunately, we can't predict when that's going to happen. It's really a function of Parliament. We recommend exercising caution and not making the incorrect assumption that because it says contractor on the contract, that it means it is a contracting relationship. The safest way is to engage legal professionals to get the structure of the relationship and contract right in the first place, but also to regularly assess the arrangement and review and update the contract if it's required. To summarise, it's a complex and dynamic area of law. Given each and every practice and relationship is unique, it makes all the more important to not choose blanket solutions. Got some time myself for questions. I understand if you've only got half an hour, but if you have any questions or feedback, I've popped my contact detail on the slide here. I do wish you every success on your practice journey, and if there's other questions, feel free to pop them in the Q&A box and I'll hang out here and answer those for as long as you need. Thank you for your attendance today. I'm going to stop sharing and I guess you'll lose my contact details, but I want to be able to look at you properly. Sharon, thank you for your comment. Glad that you learned a lot and hope to see you next month as well. Any other questions other than, it's confusing and complicated and always changing? Anna says, do you have to pay superannuation for a psychology independent contractor who chooses to work 1 day per week and the rest of the week in their own practice? Anna, it's a good question, and I can't provide you with specific legal advice here, but I'd need to see the contract and understand more about the arrangement. So feel free to book in with me. You can just reply to the emails that you got in relation to this webinar if you like, and we can book a time in and I can have a look at the contract and potentially provide you with a proposal to provide that advice for sure. Thanks for the question. All right, if that's it, have a great rest of the day, everyone. Thanks for turning up and look forward to being in touch. Thanks, Megan.